Good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors, pursuant to Law Number 26/2022. I hereby declare this session open. This hearing involves the resumed evaluation of Mr. Alexei Panis, candidate for the Superior Council of Magistracy, at present judge at the Chisinau Court Rascani office. I would like to welcome you, Mr. Panis. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Magistracy. The Commission is acting in accordance with Law Number 26/2022 and its rules of procedure. On the screen in front of you, you have the four members of the Commission: Victoria Henley, Nadezhda Rybczewski, Nona Totoria, and myself, Herman van Hebel, the Chair of the Commission. The Commission is assisted by members of the Secretariat, and the online public hearing can also be followed by representatives of the media and the public. During the hearing, interpretation between Romanian and English will be provided. To allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online generally within 24 hours after the hearing via the website of the Commission, www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On 24 January 2023, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Magistracy. In its decision, the Commission decided that it had serious doubts about your compliance with the criterion of financial and/or ethical integrity in relation to three issues. One, the source of funds for a 300,000 Moldovan lei loan and money used from your father's salary card. Two, the sale of a Kia Sorento car and cash investments in the house located in Chisinau municipality. And three, public statements by you on 19 January 2022. On 13 February 2023, you appealed this decision to the Supreme Court of Justice. And on 1 August, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 9 September 2023, the Commission started the resumed evaluation, and on 25 March 2024, pursuant to Article 19, Paragraph 1c of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 1 April 2024, you responded in writing to the statement of facts and serious doubts, and you informed the Commission that you wished to participate in a public hearing. On 16 April 2024, the Commission held an online public hearing in the context of your resumed evaluation process. One of the four members of the Commission present at that hearing resigned on 14 May 2024, and at that time, the Commission had not yet finalized its deliberations on the resumed evaluation of the candidate. The Commission had no longer had a quorum pursuant to Article 11, Paragraph 2 of Law Number 26/2022 to take a decision. The Commission decided, also based on your request dated 14 May 2024, to undertake an additional online public hearing with the participation of the present four members of the Commission. Member Victoria Henley, who did not participate in the resumed evaluation hearing of 16 April 2024, informed the other members of the Commission on 24 May that she has reviewed the video recording of the hearing of 16 April 2024 in its entirety. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request, and the hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written responses to the statement of facts. I will also briefly explain the procedure for today's hearing. At the public hearing of 16 April 2024, you were already provided the opportunity to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission in relation to each of the 3 issues about which the Commission decided it had serious doubts. At the public hearing of 16 April 2024, the Commission also already had the opportunity to ask you questions about the explanations you provided, both in writing and during the hearing. You will now be given another opportunity to provide additional explanations to complement your written responses to the statement of facts and serious doubts and your explanations and answers provided during the 16 April 2024 hearing. In conformity with the format of the public hearing of 16 April, you will be given a maximum of 50 minutes in relation to each of the 3 issues about which the Commission had formulated its serious doubts. After your explanations, 1 or more members of the Commission may have questions for you about the explanations you have provided, both in writing and during the hearings. I urge you to be concise in your explanation and answers. I also urge you to answer all questions truthfully and completely. Your explanations are important to the Commission in verifying your financial and ethical integrity. Before giving you the floor, I will read out again the serious doubts that the Commission had formulated in relation to each of the 3 issues. Issue 1 concerns the source of funds for a 300,000 Moldovan lei loan and use of money from your father's salary card. In relation to this issue, the Commission, in its statement of facts and serious doubts sent to you on 25 March 2024, the following serious doubts. And I quote, "The Commission has serious doubts about the financial and ethical integrity of the candidate in relation to his receipt and use of a loan of 300,000 Moldovan lei and use of a salary card for an amount of 85,927 Moldovan lei from the candidate's father, while the candidate was aware that his father was the subject of 3 verification procedures by NEA relating to the candidate's father's position as president of the Flores district, while at the same time being engaged in and receiving a considerable income from private economic activities in violation of the legal regime of incompatibilities and related issues of legality of funds acquired over the years 2012-2020. I would like now to give you the floor, Mr. Panis, for a maximum of 15 minutes to provide any additional comments that you would like. After you have finished, we can see whether there may be any questions from the members of the Commission, and then we move on to issue number 2. So, Mr. Panis, please, you have the floor now.
I have a question that I would like to clarify something. In the initial evaluation, it was established that there are certain materials that were not translated as far as my evaluation was concerned. This was confirmed by the decision of the Supreme Court of Justice of the 1st of August 2023. What is more, for that repeated hearing on the 16th of April, the chairperson of the Commission confirmed that out of the 3,487 pages, only some of those documents were actually translated. I would like to ask whether to this day this is also valid. Was everything translated, or was there just some selective information translated only? Did anything change since the 16th of April onwards in this regard?
Thank you very much for your question. I can answer in the very same way as I did at the hearing of the 16th of April, and that is that all materials have been translated as far as necessary, and I would like to add in written or in oral form to the Commission in accordance with its rules of procedure, Article 4, that relates to languages. So I can reconfirm that the Commission, all members of the Commission, had access to all the materials of which it considered it relevant to have access to in the language that each of the members of the Commission understand. I hope that answers your question. Please proceed, Mr. Panis.
Another question that I have to clarify something has to do with the resumption of the evaluation procedure. It is true that I asked for another hearing, but I've asked for it because I was waiting for a decision, a reasoned decision of the Commission to either reject or allow, and I will explain why. The law number 26 doesn't provide for resuming the evaluation. There is no ground for that. This aspect is reflected in the rules of procedure of the Commission. Now, according to this regulation, item 19, paragraph 1, is very clear that the resumption of the procedure can happen on the basis of a decision of the Supreme Court of Justice. So for the public hearing for the third time, though, there wasn't a decision of the Supreme Court of Justice. It is important, though, to mention that when it comes to the grounds for resuming the procedure, it would be easy to find that in the provisions of the Administrative Code. It's only that at the stage when the appeals were being examined, the representatives of the Evaluation Commission have firmly supported that the provisions of the Administrative Code do not apply. Some decisions of the SCJ have taken over those conclusions, and they said clearly to my colleagues who've had litigation there that the provisions of the Administrative Code do not apply, that there is a special law. For this reason, I really wanted to look into what would the decision of the Evaluation Commission be as regards the repeated evaluation. Will the Administrative Code apply or not? Because this is very important for the conduct of the entire process, including in terms of the appeals, because I kept being told that the Administrative Code wouldn't be applied. So that's why I wanted to see if there was a decision of the Commission regarding the resumption of the evaluation and this rehearing. And if such a decision isn't, or if there is, I would have wanted it to be part of my case file that was provided to me. That is, in case I want to use that for some further action in court. I would like to thus clarify for myself if the Administrative Code would apply or not. Over.
Thank you very much, Mr. Panis, for that question. As I mentioned in the introduction, this is not a renewed resumed evaluation after the Commission has taken a decision. What happened was that after the hearing of the 16th of April, one of the members of the Commission resigned, leading to, and at that time, we had not taken yet a decision, so there was no quorum. So in order for the Commission to continue this resumed evaluation after the first decision by the Supreme Court of Justice, sending it back to us for a resumed evaluation, this is a continuation of the very same process. So on the 16th of April, we had a hearing. On the 14th of May, one of the members resigned. There was no quorum. The member at that time who was not able to be present, Victoria Hanley, was able to be present today and is able to be present today. As I informed you, she has been able to look at the video recordings of last hearing, so it's fully briefed of all the discussions that we had with you at that time. And so this is a continuation of the very same resumed evaluation that also took place on the 16th of April hearing. And so there's an additional hearing as part of the same process. And so we will go on, and after this hearing, of course, the Commission intends to issue the resumed or the recent decision it is required to take, but now with the required quorum as well. I hope that answers your question. Please, Mr. Panis, proceed.
Thank you. Well, you confirmed that no decision in this regard exists. So essentially, I understand that the statement of facts is the same. I haven't received a different statement. So you've confirmed that the same statement continues to be valid. I've provided my explanations, all of my explanations, and you've confirmed that they have been heard by the member of the commission who was not present at that date. And then in this regard, there is no point in me providing again the same explanation. So I guess we could just move on to answering your questions if there are any. If there are questions that will require a lengthier explanation from me, then I guess I will go back to my answers and read them out loud. But since the statements of fact is the same, I expect that my answers will be repeated, but I guess it would be the right way to go would be to see if there are any questions for me to answer. And then depending on the questions, I will be adding information reflecting some circumstances that might have emerged during the evaluation process.
Okay, thank you very much, Mr. Panis. That is appreciated. Indeed, there's no need for a repetition of the hearing and the discussions that we had on the 16th of April. I assume this applies to all three issues that were discussed at the hearing on the 16th of April. Then if that is the case, then I would like to look around whether any of the members of the commission may have any questions for you. Victoria, I see your hand up. Please go ahead.
Yes, thank you very much. And good afternoon, Mr. Panis. I do have a question regarding issue number 1, and based on a statement that you made at the hearing on 16 April. You stated regarding your father's work for the two businesses that they caused no damage to the public entity that he was also serving for. And could you explain exactly what you meant by that?
Încă o dată o să explic. Deci ați referit la actele de constatare.
I will explain again. Did you mean the NIA statements of findings and that sort of, my statements in that regard? I've explained that when my father was in that public office, that public position, he was not remunerated by those companies, and you referred to them. This is a consistent, proper practice for the NIA and for courts, given that it was not established. They did not establish that the law 132 or 133 were violated. There is no conflict of interests in a situation where the person who is in public office is not remunerated. So if that person is not remunerated by the companies, there is no violation of the laws 132 and 133. And I've also provided concrete examples that confirm that those findings of theirs were actually abusive. And I've also provided to you a decision of the Supreme Court of Justice. And that decision established that there was no harm caused to public interest. And this is the explanation, the additional explanation that I can provide. With regards to the questions regarding the dividends of the company, I have right here a statement, an excerpt from the Declaration of Assets, Personal Interest of a minister. So there are dividends reported by that minister. It is not a violation. It is absolutely legal to be in public office and to also acquire income from some economic activity, as long as that is only dividends. And that I have also explained at that hearing. In the note that I submitted, or in the answers that I've submitted on the 25th of March, in the context of the resumed evaluation, there I provided a detailed account of the reasons of the matters of law that show that no harm has been caused to public interest.
In the NIA report number 52/08, they cite a contract for the purchase of agricultural products in the amount of 1 million lei, which apparently your father entered into as manager of one of these companies while he was also serving in an official capacity for the town. Do you know what that contract relates to or why it has any bearing on an issue of conflict of interest?
Well, as regards the impact in terms of conflict of interest, that's what the NIA tried to look into in detail, and the court has actually already commented on that. There is a report of the 25th of March, and they're actually distorting and skewing reality. There is a transaction entered into by two businesses, so there is no reason for that to affect public interest. So that's what established the courts as well, and that is reflected in the decisions of the courts. And what is more, that document that reference was made to is not enforced at this moment in time, and it doesn't have legal effect for the subject. So it does not have legal effects for my father because it has been challenged. It is not thus enforced.
And is that, to your knowledge, the only transaction questioned by NIA that could have possibly been a conflict of interest that resulted in any harm to the public entity?
Well, you are trying to mislead us. Well, NIA established clearly that there was no transaction. Then the NIA made reference to that one transaction only to try to show that my father was in that position. But the National Integrity Authority did not establish how that contract could have affected public interest. So these aspects were not underscored by the NIA. They were not underscored by the national courts, and therefore no harm to public interest was invoked. There were no other contracts. There are no other contracts, and no such contracts were ever mentioned by the National Integrity Authority.
And so is it correct that you are not aware that your father made any decisions in either of those business capacities or that he made a decision on behalf of the official entity that could have affected his businesses in any way?
Can you repeat the question, please? Is it that do I know if my father made any decision that would affect?
Right, in his official capacity for the town, did he make any decisions that might have affected either of the businesses that he was also serving in capacity for?
Well, I have read, and you have read, all of the documentation of the National Integrity Authority, and in none of those documents do they make reference to such decisions that could have shown that he could have had an influence from his public office. Nothing was undertaken by him from his public office of such nature to affect the businesses. So nothing was established in this regard by the NIA, and I have no knowledge of that. So certainly none impact whatsoever was happened. None of them has happened. If there was some conflict of interest, say, that would, in that regard, that would result in failing me, then I would like to ask you kindly again to look at the statement of findings against Madam Tatiana from 17 July 2014, number 128, where the National Integrity Commission established that Madam Raducanu had not declared all of its assets. And that reason was not regarded as a sufficient reason not to appoint her as a member of the Evaluation Commission. She was supposed to have a perfect reputation. And now, speaking of conflict of interest that could lead to my failing of the evaluation, that please take into account that the chairperson of the commission admitted that he has also been the chairperson of, well, he has been also a judge at the Court of Appeal for 5 days. And he was also paid for that period. And there are clear provisions in the law number 26 stating that being a member of the Evaluation Commission is incompatible with any public office. And this did not prevent him from being the chairperson of the commission while also having an impeccable reputation. Therefore, I don't see what are the objections against myself, given the alleged conflicts of interests that were actually non-existent. I have submitted documentation that was issued by the National Integrity Authority in similar cases, but only with regards to certain MPs of the current government. The National Integrity Authority had a totally different position, quite the opposite. If you go to the website of the National Integrity Authority, you will see the decisions, all of the decisions and all of the reports on the verifications performed. You can see that, and you will notice that there are no such issues in terms of allegedly establishing some conflicts of interest. The practice is very simple. It's just that not everybody is subject to the same treatment, unfortunately.
I have no further questions on this.
Okay. Then, Mr. Panis, I have one question, and that goes back to the NIA verification report of 8 September 2021. As you mentioned also at previous hearings, you were informed about the fact that the verification report relating to the position of your father and his financial income and situation, you were aware of that a long time before you took the loan from him of 300,000 lei, and also when you later on used his salary card. We discussed this before, but I would like to get that question again back to you, is whether it was ethical on your side to make use and to take a loan from your father of a considerable amount of money, 300,000 lei, while at the same time you were aware that the financial resources of your father was under scrutiny by the NIA. And I recall during the initial evaluation hearing, you actually raised a question to the Commission whether the Commission expected you to take bribes instead of accepting help from your parents, and that the help of your parents was to ensure that you would resist the temptation to engage in unlawful dealings. And I was just wondering, what exactly did you mean with that comment that you made at that time?
Your comment
was motivated in the decision from the court. You motivated it, so I explained. So there are two aspects here. I don't understand the objections on the source of the financial means in terms of the use of the salary card of my father. I emphasize that my father was a public servant, and on that card there were the incomes from that activity. So this came from the state budget. So basically, to have such a question on the source of the funds for a public servant, I'm not sure whether this is correct. We should have objections to the Ministry of Finance, or I don't know how these transactions are done. But there were exclusively funds transferred from the state budget. So it is excluded to have any doubt regarding the source of the funds transferred to a public servant as salary on the card, because other funds on that card were not transferred. Regarding the use of the loan, you mentioned the report from NIA. I know all the documents from the NIA, and I know the documents that the National Authority for Integrity didn't send to the tax authority intentionally. I asked you to read the decision, and you will see that in the text of the decision, if we add up the amounts mentioned by the inspector as incomes and the amounts that are under expenses, the incomes are more than the expenses. This is what the inspector found. So he had such an inspiration that was not encountered up to now in such a document to decide that the subject, my father, did not have the necessary amount at the day when a transaction was concluded. For example, the 30th of March or the 27th of April. So I emphasized in the meeting from the Court of Appeal, Chisinau, that in this case, the inspector acknowledged that he applied a wrong methodology. Because if we look at the fiscal year, 1st of January, 31st of December, then the calculations would have been correct. But the National Authority for Integrity stated that in 2021, in the period when I got that loan, the family of my father had incomes of more than 1,300,000 lei. So in the period when I received the loan in 2021, the National Authority of Integrity issued a document. And by the way, this is the only document issued regarding my father that is enforced. The others are not enforced and are not producing legal effect. So the only document that is valid confirming that in that period in 2020, so just in 2021, the incomes were of more than 1 million. And I received the loan of 300,000 from legal sources, from the funds that were checked by the NIA. So not even the NIA had doubts on this, because I was also checked, and I was checked inclusively by the National Center for Anti-Corruption, by the Anti-Corruption Prosecutor's Office. And there was an operational analysis report. One was presented initially in the materials of the file, and I sent an additional one filled in. So no doubts were from the NIA, from the Anti-Corruption Prosecutor's Office, from the NAC on this means. And I presented all the documents referring to the legality of these funds.
And my other part of the question that I asked you is, what at the time did you mean with when you were saying whether you asked the commission whether you were expected to take bribes instead of accepting help from your parents? What did you mean with that statement at that time?
I don't remember exactly what your question was at that point. And now I answered the questions related to the resumed assessment. That income was legal. There are no objections related to their origin, and there are no reasons for failing me for taking a loan for an amount that was obtained from legal sources and for which there is no doubt. I would like to emphasize that in the report that you sent me in March 2020, in March 25 March, there was false information. So since 2021 or 2020, the NIA did not start actions for the seizure of property because, and I described this very precisely in what I've sent. Please analyze this aspect.
Okay. Thank you. I have no further questions. Do any other members of the commission have a question? Victoria, you have another question?
Right, and I just wondered, are we dealing with 1, 2, and 3 all together?
I think, yeah, exactly, yeah.
Okay, well, I do have one on issue 2.
Okay, go ahead, please go ahead, Victoria.
Okay, Mr. Panis, NIA conducts verification of annual declarations, correct? Not as to everyone every year, but that is one of NIA's functions. Is that correct?
Usually, NIA has random verifications for certain persons. By coincidence, 2 years in a row, I was checked by NIA. Regarding the documents issued for my father, one of the report was for a routine control that was random. The other two were based on some complaints.
And in addition to conducting verifications, random verifications of annual declarations, NIA can also look into, I believe as it has done with your father, if there's a complaint or some kind of information about possibly inexplicable wealth or wealth that exceeds apparent income. Isn't that correct?
Да.
Right.
Да.
So it's
Yes. Moreover, NIA can examine anonymous complaints.
Correct. Yes. And
so this is also.
So if you have an asset such as you purchase property and build a house and incur expenses, NIA could be looking into that at some point in time. Isn't that correct?
I don't understand the question because the law is quite clear. In the declaration of assets, one includes the expenses for different services that are required. I think it is 10 minimum wages or 150,000. It could be medical services or touristic services or renovation or repair works for the car.
Okay.
If the person during a fiscal year has such expenses, so these are indicated mandatorily in the declaration of assets and personal interests. The NIA has leverages to check whether these declarations are true and to check the expenses also.
Correct. And you just mentioned renovations as one thing that they could look into if it's above a certain amount, correct?
Let me understand. You mentioned you are referring to the second topic.
Yes.
So the part related to expenses. Just a moment, I will come back to this so that I don't forget. Regarding the information from the tax authority that you presented, I received that yesterday. In the operational analysis report that was sent for the Commission, in the letter from the 7th of July 2022, 7th of July 2022, it is mentioned according to the informational system of the tax authority. In 2021, Pani Stefan and Elizaveta have an income of, and it is mentioned here, 4,032,677. I calculated several times what is mentioned in the letter that you sent me yesterday, and 1 million is missing in that letter. The idea is that the NAC and the other services are mentioning the same information system of the tax authority. And these questions how serious or the good faith of the authorities that are sending these documents to the Commission. And I will explain this along the way. But I would like to mention that the NAC mentions according to the informational system of the National Tax Authority. And we are discussing about 1 million lei. This is a big difference. On the second question, the 300,000 for expenses, if I understand correctly, the doubts of the Commission, as they were phrased in the statement, the Commission has doubts related. Just a second. The fact that the document did not present supportive documentation, which made it impossible for the Commission to check the accuracy of expenses of up to 300,000 lei. So do I understand correctly that the Commission established that I had financial means that I indicated in all financial declarations, but Commission does not know, or I cannot prove how I use those funds. These are the doubts about me. The amount of 300,000 lei, how did I spend this? So I could not prove the Commission how did I spend that 300,000 lei. Are these the doubts? So I submitted a set of decisions from the Commission that are public, and they have omissions for candidates that have passed the vetting. But there are other cases, similar cases, where declarations were not submitted, and those declarations did not include some goods. So what would be the interest of not mentioning that asset? So if for 2018, 2019, 2020, I mentioned the real price each time, even for the cars that I have sold, I mentioned this in the declarations. I mentioned the real price because I knew that this was submitted to NIA, and there are consequences if you don't mention the real price. So for all transactions, I mentioned the real price. There was no logic in me having construction works, investing in this property, in obtaining legally these funds from selling real estate, cars, loans, and not mention the money that I own legally.
Okay.
This
Mr.
amount
Panis,
should have been declared only in such case.
Mr. Panis, if we could return to my question to you, which was that you apparently recognize that renovations of real estate or a home that you own could be a subject of inquiry by NIA. If you declare it, that could be part of either a verification or some other control initiated by NIA. Is that correct?
Procurorii pot să investigheze mult, pot întâmpla.
Prosecutors can investigate this. There are many things that could happen. Basically, anyone could check this, starting from the commission and ending with the prosecutors. That could be possible. I think this is how they are working on illegal wealth cases. I believe that when the decision was issued, the incomes and expenses were checked. Of course, this can be checked. The NIA can check these expenses.
So my question to you is, as a public official, and knowing what you have to disclose each year and what could be the subject of inquiry in order to make determinations about, to ensure that public officials are not engaging in any improper activity, why is it that I understand that your position is that the law doesn't require you to keep records, but why do you not keep records of substantial amounts expended that would be the subject of an inquiry?
Dumneavoastră induceți în eroare sau ați fost indus în eroare.
Misleading us, or you have been misled. In the decision to fail me, it was said that I should have complied with obligations that I don't have. In the law on the declarations, it is mentioned that one needs to mention the expenses. Before that, it was not mandatory to have all these expenses. And the declarations were submitted as it was required by the law. There are no other obligations for judges or prosecutors. The law is the same for everyone, and we all respected the law in force. Later, probably in 2021 or 2022, the law was amended, stating that one needs to mention all expenses. So for me, regardless whether I was a judge or not, I had no obligation to keep record of these expenses. Although the Commission, in its decision, mentioned that it was a lack of appreciation on the importance to keep track of this amount. There was no provision on this. I followed the provisions of the law, and I submitted the declarations in the form that I was supposed to do this. There was no laws saying that I should have made this bookkeeping. When the law was amended in 2021 or 2022, I don't know exactly, all expenses or all services exceeding a certain amount are indicated. This is because we need to mention how this was spent. But before that, this was not provided for. And I had no obligation to keep record of this. But of course, had I had this obligation, I would have done this. But I didn't know that in a few years, I would have to prove how I spent an amount that I owned legally. Similarly, we would have to say that we can take the salary of each public servant and ask how they are spending it. If they can spend it the way they want it, if it's for legal activities, this is the same thing that I did.
I have no further questions on this.
Okay. Anyone else from the commission? Any questions on issue 2? Any questions on issue 3 either? Okay, in that case, we have finalized the discussion on the 3 issues. And I would like now to give you, Mr. Panis, the opportunity to make a brief closing statement at the end of this hearing. Please go ahead.
Unfortunately, today not all of the members of the commission are here, not all of those who were there the last time, but previously I filed a request of recusal with regards to a member of the commission, and that was Madam Raducanu. I had explained in that application, in that request of recusal, that she is the advisor to the President of Moldova. And in my opinion, if the President of Moldova is openly threatening judges with the solutions of the external evaluation, she couldn't have been a member of this commission. Today, Madam Raducanu is not here, but I would like to show something, the Commission. This is the agenda of the Supreme Council of Security under the President, approved by the President of Moldova, Sandu Maia, on the 26th of January 2024. And it is perhaps symbolic, but the matter they looked into is the influence of oligarchic groups on justice. So Madam Raducanu, on the 26th of January, was still one of the members of that and was participating in the meetings of the Supreme Council of Security. She was participating in that, and on the agenda, on the list of participants, it says that she is the chairperson of the Center for Legal Resources and a retired judge, which confirms the fact that Madam Raducanu, just a second, if I may.
Mr. Panis, I would briefly like to interrupt you. As you know, Mrs. Raducanu has resigned last month from the commission. So any references to your motion for a recusal for a member that is no longer a member of the commission is completely moot. So the issue is totally irrelevant for today. So I don't think we have to continue with this discussion. Is there anything else,
anything else? Bine.
Something else, all right, then I will not refer to that motion of recusal. I will not talk about it, but that because that is a matter that has already been discussed. Still, I've read all of the decisions of the vetting and pre-vetting commissions, all of the decisions that are out there. I've read them all. Now, the reformers are trying to convince us that the vetting had the purpose to get rid of the judges and prosecutors who were implementing political decisions and who stepped and trampled human rights. I've read the decisions, and none of the decisions of the vetting or pre-vetting commissions have I found findings like this. The motto was around the unexplained wealth and the robbery of the 1 billion, and I've not had decisions, I haven't seen decisions addressing matters like that. However, I found a letter signed by Veronica Dragalian, head of the Anti-Corruption Prosecutor's Office, and I understand that we still have the presumption of innocence principle, but still we have to also think about the integrity matters, and it confirms that after 2 years of vetting, apparently the only person who has connections with the people involved with the bank fraud and the robbery of the 1 billion was Madam Raducanu. And that's not me saying that, but that's the prosecutor saying that. And I hope that the innocence is proven, though it is regrettable that such manipulations are taking place. Essentially, there were violations of the provisions of the regulation that the Commission has observed, the provisions of the regulation, and that is very easy to see. I've read that out loud, everything that related to translations and the gathering of evidence. And I was trying to find a rule that was being observed, and I didn't come across one. And I regret that the pre-vetting will pass and the vetting will pass, but everything that will have been done will remain and it will leave traces. And well, recently I've said that there are 2 things that will be symbols of the evaluation. That was the case of Iulian Munteanu and the hearing of Ioan Chirtoacă. I think there will be 3 cases, and that is the fact that Madam Raducanu was on the vetting commission. Unfortunately, at the public hearing, the mother of my colleague had even cried because she was feeling that her family was being humiliated. But if you read carefully the letter of the prosecutor, Madam Dragalin, you will see that other people who participated in the evaluation were apologizing and were almost crying for not having managed to implement the orders of Vyacheslav Platon. And that's what the prosecutors have been writing in the letters. Still, I am asking a question. Who is evaluating who? And who should actually be subject to an evaluation? As I've said in the previous hearing, unfortunately, manipulations have been taking place in a very rude and blatant way to get rid of the inconvenient candidates. I had a very serious attitude towards this process, and I answered all questions, and I submitted decisions, similar decisions that show that at least if my answers are not allowed or not accepted, then I should be given at least an explanation as in why other candidates have been treated differently, at least. All that I want is to be treated on equal footing, on equal terms with all the other colleagues who've passed this evaluation. That is all. And I hope that at the next hearing, we will have the same membership. And that's all I can say. Over.
Thank you. With your closing comments, we come to the end of the hearing. I thank the candidate for your submissions today and answers to the questions from the Commission. The Commission will now withdraw for deliberations, and as much as possible, will strive for delivering a reasoned decision within a month after the date of the hearing. I hereby declare this hearing. Thank you.